Welcome back, Mr. Lysenko.
Thank you, Honor.
It is Mr. Bowtie available.
I'm
Excellent.
here.
So Miss Boulay, are you ready to go?
I am ready.
And Miss Crane?
I'm ready.
Okay, we're back on the record and proceeding number 25F-0270CP. And we're continuing with the direct examination of Mr. Bowtie. So, Mr. Jennings, you may proceed.
Thank you, Your Honor. Miss Crane, if you are still driving here, could you please pull up Exhibit 203? Thank you. Mr. Bowtie, can you tell us if you're familiar with this document?
I am familiar with it.
Can you tell us what it is?
This is our website as of 6/6/25.
Okay. This is On Location's website.
It is.
And you mentioned a date. Can you direct us to that date?
Date and timestamp is in the top left corner, 6/6/25 as of 2:55 p.m.
Okay. And Ms. Crane, if you don't mind just scrolling through, I'll ask Mr. Bowtie if this looks like a correct copy of your website that existed as of June 6, 2025.
It does, yes. You'll notice the bus was removed, and there's some change to the language right there that we're scrolling through as well.
Okay. Your Honor, we would ask for admission of Exhibit 203.
Any objection, Mr. Lysenko?
Yes, Your Honor. The same objection that it's incomplete. I mean, this exhibit's been prepared that it's cut in corners, covering the headers, partial of the page, so just incomplete.
Understood. I'm going to go ahead and admit it, and I will attach the appropriate weight in light of its incompleteness. So go ahead, Mr. Jennings.
Thank you, Your Honor. So, Mr. Bowtie, well, let me ask you this. Do you mind scrolling up, Miss Crane, to the top? Thank you. So this website that we're looking at now, did you make changes to this website after Judge Adams issued his decision in the first complaint case?
We did.
And was that the decision that was issued on May 29th?
It was.
Okay. And so you made those changes roughly 6 days, 7 days after the issuance of the decision?
Yeah, I believe the decision was issued at the end of a week, so I believe we had the Memorial Day holiday that slowed us down a little bit.
Okay. And did you take into account the written decision that Judge Adams issued when you made changes to your website?
We did. We took guidance from our counsel and internally for the updates that we made.
Okay. You may have heard Mr. Lysenko talk about earlier that he believes some companies are unaware of PUC guidance or are ignoring PUC guidance. Did you ignore the judge's decision that was issued on May 29th?
We did not. No, you can see in this screen right here, we added language right there saying transportation brokerage. We removed a bus because, we aren't wrapping buses that say Shuttles to Red Rocks. That's not what we do. The buses we drive up there say Ace or Rambling on them. And then we updated the language below in that red box to better outline the word brokerage and outline what we were doing with the program.
Okay. Ms. Crane, do you mind scrolling down to to page 2 there. Thank you. Yep. So we're looking at a red text box in the middle of the screen. Do you see that?
I do.
And did On Location come up with this red text box in response to Judge Adams' decision?
We did, yes. We adjusted it in response to his decision, particularly the first few lines there.
Okay. So I'm going to ask you a few questions on this one. Did you update the actual written content of the notice?
We did, yes. So the On Location is a transportation broker. What you'll notice is different from the language that we had in that same box prior to the ruling.
Okay. And what about the box itself? Did you change the font? Did you make it more prominent? What did you do differently from what we looked at just before the lunch break?
You know, I'm not sure when it changed, but we did have these pretty gray, pretty dull, and the red and the font was not necessarily the color of the font was made to kind of bold this out and really call this out on our website to make it more visible.
Okay. And just kind of for context, are we still looking at the main web page that customers visit, the rrxshuttles.com?
We are.
Okay. So is this the first thing that a customer is going to see scrolling from the top of page 1 through the top of or the middle of page 2 here?
It is.
We've talked about a big red bus image. Was there a big red bus image that was appearing on prior versions of your website?
There was. That was at the very top here, where you see the pictures of the rocks, that was removed.
Okay. So did you remove that image in response to Judge Adams' decision?
We did.
And did On Location ever actually operate a big red bus with the name Shuttles to Red Rocks on it?
We did not. No, that would be too cost prohibitive to wrap the buses and advertise like that.
So was that a stock photo or just sort of a branding?
It was just sort of a branding. Yeah, that didn't come from any sort of bus. That was made by our marketing assets in house.
Okay. So you don't have to read it again, but does this version of the website that we're looking at right now advise the public that On Location is a transportation broker?
It does.
During the course of today, we've looked at different, I guess, pages, ticketing, secondary pages. If a customer wanted to purchase a ticket or link to a specific concert, do they visit this main webpage first?
They do.
Okay. And from there, they may find information on specific concerts or how to order a ticket?
Correct. There's different areas where you can view the different concerts, view the different stops through the map on how we get guests back and forth from the venue.
Okay. And is this, because Mr. Lysenko showed us, I think, a document from October. Is what we're looking at here from June 6th essentially the same document that you discussed with Mr. Lysenko?
Yes, the only major changes that are happening on here are adjusting the shows that are being announced and concluding up at the venue.
Okay. I'm not going to ask you about legal advice, but did you work with legal counsel to review and take responsive actions once Judge Adams issued his decision?
We did.
Did you work with your IT department to implement the changes that the company determined were necessary?
We did.
Okay. Did you implement those changes as swiftly as you could?
We did.
Thank you, Miss. Next exhibit, please, Miss Crane. That will be 204.
Let me just ask about 203 really quickly. So that was as of June 6, 2025. That was the date on it, right, Mr.
It was.
Okay. So, focusing on we'll just call it a disclaimer, the big red box that you just noted, and then the omission of the bus with your company's name on the side of it.
Yes.
Both of those had been taken. Well, the bus had been taken off, and the big red box became a big red box with some language changes as of June 6th.
As of June 6th, yes. And then the paragraph, there's a small paragraph at the top of left of on the first screen, and the word brokerage was added to the bottom of that as well.
Okay. As to those elements, has anything changed since June 6th? Maybe I'm getting ahead of myself, Mr. Jennings. If I am, I apologize, but go ahead, Mr. Bowtie.
No, you're not getting ahead of yourself. And nothing to those disclaimers has changed.
Okay. Mr. Jennings, go ahead.
Okay, thank you. Yes. Exhibit 204. Mr. Bowtie, could you tell us what this exhibit is that we're looking at?
Yeah, so this is I would call a sub screen of the website. In the last sheet that you guys saw, you saw that little button that says view map. This is the version of our map that shows the Thirsty Lion, Illegal Pete's, our 2 stops. This is of June 6th, 2025 at 3:03 p.m. If you scroll down, we had added similar language about being a third-party provider to this page as well.
Okay.
And this was changed after the rolling.
Okay. Yeah, I just want to hone in on the timing. So at the top of page 1, point to us how you know when this website was active.
So there's a timestamp on the top left of this screen, 6/6/25, 3:03 p.m. So when this was taken.
Okay. Is that the same date when you implemented the change to the main web page that we just looked at?
Yeah, the majority of these happened within the same 2 to 3 hour period as we worked with our tech team.
Okay. And so this, well, Your Honor, I would ask for admission of exhibit 204.
Mr. Lysenko. You are muted, Mr. Lysenko.
No objections, Your Honor.
Okay, thank you. It's admitted. 204 is admitted.
Okay. Mr. Bowtie, I'm going to ask you a few similar questions. Did you make changes to this web page after Judge Adams issued his decision?
To my knowledge, we did. We added the language that was below.
Thank you. That's great. Mr. Bowtie, what are we looking at here? This image towards the bottom?
A picture out of the front of a bus.
Okay. Does On Location own any buses in Colorado?
We do not.
Does On Location lease any buses in Colorado?
We do not.
So would this bus be a bus
Your
that
Honor,
is,
I would like to object. The question is about On Location, if it owns the buses or not about the advertising.
Understood. I'm going to overrule and allow the testimony.
Thank you, Your Honor. I mean, this is On Location's website, so it is an advertisement of On Location. So I'm asking detail.
I've already overruled, so go ahead.
Mr. Bowtie, who would this bus be owned or operated by?
Ace or Rambling Express.
Okay. And just to tell us what the relationship is between this page and the prior page we looked at. Is this a secondary page, or how does a customer get here?
This is a secondary page. There's a button on that top page that says View Map and takes you to this map that shows the different stops, bringing you up to Red Rocks and back.
Okay. Thank you. Ms. Crane, could you please pull up Exhibit 205? Thank you. I believe this will be our last exhibit. Mr. Bowtie, can you tell us what we're looking at here?
We're again looking at our website. This is for in particularly our FAQs, which you can see. You can click through at the top of the website here. FAQ gets you through a group of general info, safety, and shuttle time and location questions that guests ask us all the time. The website's from January 6, 2025 at 3:08 p.m., which you can see from this timestamp in the top left.
All right. Is that June 6th?
June 6th. Sorry.
And was this the same date as the prior two exhibits, the websites we've looked at?
It is. Yes.
Okay. Ms. Crane, do you mind just scrolling through, and I'll ask Mr. Bowtie if this is a correct and accurate version of the website that existed at that time?
It is. Yes, it is. You can see the two questions that we had added at that top section of questions addressing the third party vendors.
Okay. Your Honor, we would ask for admission of Exhibit 205.
Mr. Lysenko, any objection? And you're muted.
No objections, Your Honor.
Thank you. 205 is admitted.
Thank you. Ms. Crane, do you mind scrolling back up there to the top of page 1? Mr. Bowtie, tell us, I mean, I think people know what an FAQ is, but tell us what purpose does this page have with regard to On Location's advertising?
This purpose is to give guests all the information they need regarding not only this event, but how you can get to and from Red Rocks, and to provide all aspects of transportation. We answer a lot of those questions that come back to our guest services, to limit emails, to limit calls, to help get the guests as much information as they can get ahead of time, rather than asking on the fly.
Okay. And on this FAQ page, did you make specific changes in response to Judge Adams' decision?
We did. We added a question here that you can see. Are you the shuttle provider? No. On Location is a transportation broker. And this is the same language that we saw on previous pages in the big red box that we had spoken to.
Okay. Ms. Crane, could you scroll down a little bit? I'm not sure if there's anything. Oh, could you
Yep. How does it
tell
work?
us what else you changed?
We essentially added that same blurb that we've been adding to underneath another question on how does it work, just to try and double down and get to the question and make sure this is as visible as possible.
Okay. From On Location's perspective, does this make it clear to customers who is the transportation provider and who is not?
It does.
If a customer asked On Location for more information about how this works, would you engage with the customer or tell us about how that process would go?
Yeah, so we have a number of different ways we engage with our customers. We have a full-time call center that they can call into. We have email responses through our website. You can chat with our guest services, and we normally like to pride ourselves in a 12 to 24 hour turnaround time for any emails or calls that get sent our way.
Okay. No further questions on the exhibits or on the screen. Just overall, Mr. Bowtie, did On Location significantly change its website from where it started here in May of 2024?
I believe we did, yes.
And did you make those changes were there 2 rounds of changes, or tell us just at a high level, what are the different versions of the website that you changed?
Yeah, there were 2 rounds of changes. You know, we took legal advice into account ahead of the May ruling and wanted to, make sure we were playing it, getting as close as we could to what we heard the complaint was to be compliant. And then we took further changes after that 529 to even further outline the brokerage that we are, and did that so that, because back to my prior statement, we're always aiming to be as in line with every law we need to follow.
Okay. Does On Location believe that you are complying with all laws and rules here in Colorado?
Yes.
You may have answered this before. Well, I think I asked Mr. Lysenko, but has PUC staff contacted On Location about your compliance since May 29th?
They have not.
Okay. If you had that type of outreach, would you be willing to work with commission staff if they have additional guidance for you?
Of course, yes. We'd be willing to take any additional steps needed right away.
Okay. If you receive any new guidance in other written orders or changes in rules, would you comply with that guidance?
Of course.
No further questions, Your Honor.
Okay, thank you, Mr. Jennings. Mr. Lysenko?
Thank you, Your Honor. Mr. Bowtie, I just got a couple questions. You mentioned that there are some other companies similar that runs programs similar to your program. Who are those companies?
I don't know any of the names that they're represented under. I don't know any of their LLCs, but we see them parking buses next to us, similar to yourself. Every day we're up at Red Rocks.
Got it. How do you know that it's a similar program?
Because we follow all of our, we follow the same as you obviously do. We follow our partners, and we follow how our partners are selling and marketing themselves and advertising themselves across the entire Colorado market as we do any other market.
Got it. Are you talking about Rocky Mountain event shuttles? That's the only company parking with us.
I don't know if that's the name that they're written under, but the reports that come back to me is that at one time we were that company up there, and now there are multiple different companies in the area doing the same services that we provide up to Red Rocks. I'm unaware of the actual entities' names, what they're running under, any other details around those entities.
Got it. You have testified about disclaimer a lot in your testimony. And is there a reason that there is no ACE or Ramblin Express names or information in the disclaimer?
There is no particular reason. Yeah, no. I mean, we haven't addressed that. It didn't really occur to us that needed to be added. But they've been great partners to us for many years, and we've worked with them for years. So I don't think either way there just hasn't ever been anything talked to, because as we've said, we handle all of our own advertising, website builds, and everything. Does not involve that.
Thank you. And do you remember Exhibit 203, who scroll down with the windshield of the motor coach, large bus? And you said it's one of the ACE or Ramblin Express buses. Is there, by looking through that windshield, how the customer can tell whose bus is that?
I do not know how they would tell if it was an ACE or a Rambling bus. If they ride those buses a lot, maybe by the driver, but no,
All right. Thank you, Mr. Bataille. That's all my questions, Your Honor.
Okay, thank you, Mr. Lysenko. And I don't have any questions for you, so Mr. Botai, thank you very much for your testimony, and you're excused, but I suspect you're going to stick around anyway. So,
Thank you, sir.
so Mr. Jennings, what's next?
We have no further witnesses, Your Honor.
Okay, so I take it you're resting?
Yes.
Okay. So, Mr. Lysenko, do you have a rebuttal case you want to put on? And you're muted.
Thank you, Your Honor. Not the rebuttal case. No rebuttal case.
Okay. Thank you for that. So I'm going to go ahead and close the evidentiary record. And the question is next steps. Mr. Lysenko, at the outset or at some point earlier in this hearing, you raised the possibility of a closing argument versus a statement of position. And the question I have is, what would you like to do?
I would like to go for closing arguments right away, right now. I believe the evidence, it's not much evidence being submitted, and I believe they were pretty clear. So the positions both sides have are pretty clear. So I will just go for closing arguments.
Okay. Mr. Jennings, same with you?
Yes, just to do an oral argument. Then Your Honor will take the case under advisement.
Yep.
Yes, that works.
Okay. So that's what we'll do. So, Mr. Lysenko, your closing argument, please.
Thank you, Your Honor. So in the previous decision, allocation was found in violation of both main advertisement rules that breaker can violate, 6016B and 6016C. So it's been offering to provide advertised service, and it's advertised transportation service from Part B without notifying customers. So then application showed the disclaimer. So, and after that, the LJ made a note that it's a good faith attempt to achieve compliance, but not actual the compliance. Obviously, because the other part left behind to see. So from that point, the LJ already saw the advertisement. It's already saw. He's already saw the disclaimer. So after that, according to testimony, on location changed. They colored the box. They added the on location as the broker, and they removed the large bus. So off of the website. So since that, they changed the color on the background of that and removed the bus. So the issue wasn't about the bus in that proceeding. So today, Ace and Ramblin testified that they have nothing to do with on-location advertisement. They never ask to advertise their service. They never discuss advertisement with the on-location. So on-location cannot say that it's advertising their service. Furthermore, on-location actually testified that it advertises own shuttle tickets. Advertises own shuttle tickets, and then putting those people in the motor coaches that hired by Ramblin Express or Ace. The problem with that is it's already been discussed in the preceding merits with the decision R25-0879 by Judge Rosenberg. And the problem with that, she already stated it's a case law that the, just one second, let me just pull it up real quick. So in paragraph 116, she stated that, moreover, a broker is an intermediary that arranges transportation between parties. A broker does not create, alter the goods or services it arranges. That is, broker arranges a one-to-one transaction where the service offered by the broker to consumers is the same service offered by the ultimate provider. The broker merely connects customers with the provider. If transportation broker sells shuttle tickets, but arranges charter transportation, as the case here, changes the nature of the service, because the service offered and sold by the transportation broker is the shuttle service, and it's not the service ultimately provided, which is charter service. So that's kind of the problem right here. So, and in the decision that ALJ made, recommended decision, in paragraph 107, he stated clearly that because on location advertised transportation service as their own service and advertising to provide transportation service, and that comes from the 1660C, which it says advertising other service other than by brokerage is the offer to provide advertised service. So, and
So, Mr. Lysenko, let me just interrupt for a moment. Your latest statement, you're referring to, I think, paragraph 107 of a recommended decision. I think you're referring to paragraph 107 of Chief ALJ Adams' decision on that one. Is that right?
Adams. Yes, you're correct.
Okay,
So,
thank you. I apologize. Go ahead.
no problem. So, and his actually note in paragraph 107 clearly stated that on location undoubtedly offered to provide transportation service. He marked it with the 81 in the footer. He marked 81 with the rule 6016C. So there is. It's been already noted that allocation in violation of Rule 1616C. Well, allocation was a violation of both Rule 6016C and 6016B, but then once it added the disclaimer, it did knock out the 6016B, which left the 6016C still hanging up there. And in the previous decision, those violation of those two rules, they lead to violating of 6016A and 6202A also. Chief LJ ordered on location to cease and desist from providing and offering to provide service until such times that on location complies with all statutes and rules governing such a service. And on location never did. On location just keep going, remove the bus. The Chief LJ already saw the disclaimer. It was the good attempt, and it was just to show a good attempt, but it's actually never complied with the rule. So on location, just remove the bus on June 6th, large bus advertisement, and just proceed with advertising their service. So as we saw today, on location stated that they sell own buses. As on location stated today that there is no place on the website where on location list information about Ace or Ramblin Express. So furthermore, the definition of the broker is stated in Rule 6001 3Ws, and it says transportation broker means a person who for compensation arranges or offer to arranges, according to advertisement, offer to arranges for hire transportation of passengers by motor carrier under authority not being operated by the broker. So again, on-location advertises shuttle service, sells own ticket. The providers, service providers, they have charter buses. It's no way that on-location can advertise their service because they don't have such authority. And it's no way that on-location can actually be even like that it can even look like a broker because it does not operate under somebody else's authority. Furthermore, Chief ALJ, in his recommended decision, he brought the case law from the previous case, and in paragraph 79, he stated that one key distinction of the transportation broker is that they undertake no responsibility to the passengers after the passenger is placed with the authorized carrier. The disclaimer they have on the website, it says, please contact us and we will contact them, authorized service providers. So they do not disclose who the authorized service providers. They do not even let the customers contact. So they still hold in some responsibilities after transportation being provided, and people can contact them with complaints, and so they cannot be treated as a broker, not even if they're gonna label themselves as a broker. So furthermore, so they do undertake the responsibility to the passengers. And the graphics on the website, that large big bus, is just a broader violation of 6016C. So the full rule says advertising to provide transportation service or advertising not by a brokerage. So that first portion, it covers the graphic, which calls for we, us, we're gonna provide. The second portion of the 6016C, that's when they advertise actually by the brokerage. They advertise somebody else's service and they advertise. They've been in violation of both. Specifically noted by the Chief ALJ in the previous order, in the paragraph 97, he actually stated, well, that was I apologize. First of all, it's been stated at the interim decision, which becomes the prima facie showings. And it was the paragraph 97. He actually highlighted in bold, in italic to make his point, and he added emphasis added, talking about rule 6016C. He actually highlighted the second portion where on location been found advertising not by a brokerage and advertising other service. Then in recommended decision, in Chief ALJ in paragraph 46 and 47, talking about federal regulation and why they don't apply to on location, those preemptions don't apply to on location, he stated that while these two aspects, specifically in paragraph 47, while these two aspects are obviously related, the fact because tickets were sold by on location to transportation on ACE and Ramblin Express charter buses rather than the advertised service. So he specifically stated that the preemption, that federal preemption, does not apply to on location because they simply do not sell or offer or advertise the same service that ACE and Ramblin provide. So again, today on location stated that we sell our tickets. We basically, they stated that there is still no information about actual service providers on the website. Their disclaimer still shows that on location undertakes responsibility. So on location still does not comply with the Chief ALJ order. The order was stop and cease and desist until it complies with the whole regulations. And that's pretty much the regulations was the rules were that been noted in the decision. It was 6016B, 6016C, 6016A, and 6020A. So allocation did not stop providing. They did not contact, furthermore, they did not even contact PUC to confirm, are we doing it right? Is it what the LJ wants us to do? They have not contacted. They actually went even further looking for the loophole, not obtaining the license. They removed the advertising, they submitted the disclaimer, everything, but did not actually start advertising by brokerage. So, and on that, in that proceeding on merits by Judge Rosenberg, the company, which is Rocky Mountain Event Shuttles company, which followed the allocation lead, and they did everything the same. They worked with Ace and Ramblin' Express, and they've been actually required to cease and desist, and the decision was made to cease and desist. And they did have the disclaimer also on their website. But Judge Rosenberg stated that it's actually, it's not enough, basically. The broker must comply with those two rules, specifically B and C, 6016, and advertised by the brokerage somebody else's service under somebody else's authority. So as we see, the cease and desist orders don't work without assigning penalties. It just spreads out and companies just following the lead. They just operating for a year and a half, redirecting traffic, making revenue, and then they kindly ask by PUC to stop providing service. And it just doesn't work like that. I know at least other 3 or 4 companies that follow the allocation leads, and they are doing exactly the same thing. And I know that the local service providers, there are not many of those. They're talking pretty much in that unauthorized, from that unauthorized competition. They don't know what to do with that. I know previously from my past experience, I know a couple companies that actually dropped the PUC certificates because they couldn't keep up with unauthorized service providers. They actually just, because unauthorized service providers, they don't have to comply with the rules, rates, they don't need to have tariffs controlled by the PUC, they can stop providing service. Actually,
So Mr. Lysenko, let me just interrupt. I understand what you're saying. You're very far afield of the evidence in this proceeding. Continue on, but it's not, the argument you're making now is not something I can rely on in this proceeding. So.
Got it. Thank you, Honor. The Colorado revised statutes 40-10.1-201, especially first part, and 40-7-113 first part as well, and the rule 6202 operating or offering to operate as a common carrier in intrastate commerce without first having to obtain CPCN from the commission for operating of violation of the certificate calls for 1,100 per violation, and each day is the new violation according to the Colorado revised statutes pursuant to the rule 40-10.1-114. So another rule, 16, violating the restrictions on offering or advertising transportation service is $500 per violation. And it's also every day is the new violation. And it's actually 500 per day, basically. Because allocation ignored the decision, ignored the order, especially part 3 to cease and desist, and proceeded it without start advertising by the brokerage and start actually advertising somebody else's service. I'm not sure, find the service providers or wherever. So, but they proceeded without actually doing it in the right way, compliant, proceeded without being, so they proceeded before they complied with the rules as ordered, called for. And it didn't cease and desist. I request that those fines would be assigned actually in this case. Since it's already a second time, they just keep violating. By the rule 1619A, and that's the PUC rule 723-6. So since it's already a second time, second event, gonna be those violations and penalties should be doubled. So if today the on location actually testified that they operated up to today's date, they advertised own shuttle tickets up to today's date, pretty much from May 29th, which add up to 196 days of violation, including today. So the complainant requests that the commission order represent to pay civil penalties in the amount of $627,200. So I respectfully ask the commission to enforce its rules, protect the public, protect the authorized service providers, and order on location to cease and desist, assign penalties, and should on location continue ignoring cease and desist orders, I respectfully ask the commission to apply external remedies, such as action taken into the district court. Otherwise, everybody will keep providing this service with the big O excuse. Oh, we didn't know. Oh, I didn't read it correctly. So, and this is the second proceeding we're going through, and I'm pretty sure if the penalties will not be assigned, there is going to be the third one. Thank you, Your Honor. This is my closing argument.
Thank you, Mr. Lysenko. Mr. Jennings.
Thank you, Your Honor. So the testimony here today, Your Honor, is that On Location is a responsible and compliant business operator. They operate in the hospitality, sports, concert, entertainment space. They operate nationwide. And in Colorado, they're involved with the Red Rocks transportation program. Mr. Lysenko's narrative here that On Location is ignoring the rules, that they're trying to find a loophole, is completely false. To the contrary, the testimony from On Location is that they closely followed the guidance issued by Judge Adams in the decision in the first case. And they would continue to follow guidance from the commission and commission staff. Mr. Lysenko has just discussed a lot of things in his closing. The relevant issue for today's hearing, Your Honor, in this proceeding is the advertising of On Location. And that comes from Judge Adams' decision. The four parties participated in a very lengthy proceeding. Mr. Lysenko, just like On Location, received a final decision in that case. He's making a lot of the same arguments. He's asking for a lot of the same relief. And Judge Adams did not grant that relief. Judge Adams focused exclusively on Location's advertising. And it's essentially the second half of that entire decision, which On Location read closely and is complied with. And so we've talked about today 3 different rounds of relevant advertising. The first one is the original. That was the baseline from May 24. That's when On Location was found at fault. They did not have adequate disclosures or advisements about what their role was and the fact that underlying transportation providers were involved. And pointing to Judge Adams' decision, He states that in various different ways, but in paragraph 119, the offense here is the advertisement appearing on location's website at the time the complaint was filed. So that's the original website, that's the original complaint. Paragraph 116 speaks to the cease and desist. It says On Location will be required to cease offering transportation without disclosing that it acts as a transportation broker. So Mr. Lysenko is making light of the fact that we have a disclaimer. The disclaimer is the vehicle to make clear to customers that there's going to be a third-party transportation provider driving them. They removed the bus. They did other things after closely reviewing Judge Adams' decision that comply with the decision and was a good faith effort to follow that guidance. The testimony from Mr. Bowtie was that they rolled it out as swiftly as they could. I think it was roughly 6 days. The dates are in the record. The version of the website that we looked at today through Mr. Bowtie was several days earlier before Mr. Lysenko decided to file his second complaint. And so they had already undertaken that effort to update their advertising in response to Judge Adams' decision. We believe a lot of this is outside the scope, but just to emphasize in our defense, we have asserted several affirmative defenses in our answer. One of those is claim preclusion. Mr. Lysenko is barred. He's not allowed to relitigate the prior claims. And that includes claims that this is an unlicensed service, that the transportation is unlawful, and many of the same claims that he has made in his closing argument today. Mr. Lysenko had his day in court. The parties went through a 12-month proceeding, and there was a final commission decision. And On Location, for its part, has done everything it can to comply with that decision. The transportation broker rules are tangentially involved here. On Location has looked at those closely and has complied with the rules. Mr. Lysenko has offered essentially his preferences on how he may advertise differently than On Location has decided to. There's no requirement in the rule that you list the names, the contact information. All of that stuff is probably palatable to On Location, but it's not in the rule. On Location has followed the rule, and it has closely followed Judge Adams' decision. And that's really the narrow issue that we are here to decide in this proceeding. And for those reasons, Your Honor, we believe the evidence shows that On Location has complied with Judge Adams' order. That was the subject of the complaint. That's how we are here with a narrowing of the issues. And for these reasons, Your Honor, we ask for Mr. Lysenko's complaint to be denied. Thank you.
Thank you. Well, let me thank everybody for the presentation here today. It's been efficient, it's been good, and I appreciate it very much. So with that, let me wish each of you a good day and a good holiday season. As has been noted, I'm going to take this under advisement and issue a written recommended decision in due course. As you all know, after I issue my recommended decision, you will have 20 days. Anybody who's dissatisfied with my decision will have 20 days to file exceptions regarding my decision, and then the 3 commissioners of the Public Utilities Commission will address any such exceptions at one of their weekly meetings. So that's the process from here. So let me thank you all again and say we are adjourned. Thank you.
Thank you, Your Honor. Happy holidays.
Thank you.